Malad, may I be permitted to mention one Group 9 application for inclusion, Malad? Deeply obliged.
Lord, may I be permitted to, without certified copy of the, my lord.
Have you applied for the
My lord, 15 January applied, my lord.
My lord, may I be permitted
My
to
lord, 13 January,
13 January.
my lord.
mention to file an appeal, my lord, prefer an appeal without the certified copy.
your date of the order?
Date of the order, my lord, is, my lord, 7/11, but we have applied it instantly. It is still pending. We have not, I've annexed the,
No, we'll ask them to issue the certified copy today itself.
my lord, it is not my lord's order. It is a unanimous appeal against an order passed by this learned single bench, Justice
So we
Amrita
will
Singh.
ensure that you get the certified copy by today.
My lord.
Give a photocopy of the application for certified copy.
I'll be supplying.
That slip.
Much.
Permitted to make an income tax matter. This matter has been resolved. Appellant has gone to the scheme and has made the payment. I'm only praying let the matter appear in the list so that it can be disposed of.
Day slip.
I'm mentioning upon notice.
Who will appear for the department? Someone will appear.
ERCL. Umnar and
Mr. Rai. Take down.
and myself, my lord.
You will appear.
আমাকে তো নোটিশ দিয়ে দেখছো
The matter has been shown in the days list. It's submitted by the learned advocate for the appellant that the appellant assessee has availed the benefit of the VSVS scheme and the matter has been resolved. Recording the said submission, the appeal stands disposed of on the said ground. The substantial questions of law suggested are left open.
I'm grateful. Please look.
That's it.
Madam, mentioning a matter on notice, my lord. This is a matter, my lord, DVC matters, where my lord, it had appeared where there was a direction to give undertaking and there will be no.
Come on Monday. Oh, Monday is holiday.
There are several applications filed by.
My subsequent also, there we have filed applications.
No, it was running in the
It is
list.
running in the list, my lord. But there's
New application.
new applications. I'm grateful, my lord.
Will be on Wednesday.
Wednesday. I thought. Yes, please call. First appellate side matter.
Your Lordship, in this matter, I've prayed for withdrawing the matter, Your Lordship.
Have you got any letter from your client?
No, Your Lordship, but the client is the authorized representative is present over here, Your Lordship.
You please give his name and designation.
Your Lordship.
The learned advocate for the appellant submitted that she has instructions from her client to withdraw this appeal. Mr. So-and-so, so-and-so is present in court and agrees and also reiterates that the appellant seeks to withdraw this appeal.
02.
Recording the said submission, the appeal stands dismissed as withdrawn. You give the name of that officer.
আমি সব দিয়ে দিচ্ছি এখানে লিখে দিচ্ছি
This is my instance has come, my lord. Your lordship, my lord, passed the order already, recognizing the Shanmugha value judgment. And my lord, in the last page, the bank authority also agrees that yes, everything to be done after the order. My lord, required only the balance money has to be paid to them and 30%, and then my lord, they will be providing me the sale certificate and the possession. The last page. And prior to that, my lord, we have recorded that without the order of the court, you have said that you will not be going through the matter. That is the reason why, my lord.
So in the order dated 25th September, we have said, in the meantime, if settlement has fructified, liberty is granted to mention. What is the settlement now?
My lord, settlement, my lord, they are saying that order of the court is necessary because of the fact that 30% money to be deposited requires the order of the court.
That we can issue.
That is the thing. And then, my lord, they will issue the sale certificate.
My lord, because
the possession.
in terms of the SARFAESI rules, my lord, the bank authorities, my lord, are without jurisdiction insofar as extension of time beyond 180 days are concerned. My lord, we will be acting without jurisdiction if we of our own extend it. Lord,
My respectful submission is concerned that it has been agreed now today as per Shanmugha judgment that other than 25% deposit, nothing can be forfeited. They sought to forfeit the other monies, and that is the reason why, my lord, today they possibly cannot say that order of the court is not necessary. My lord, that is the reason why, my lord, we are before your lordship.
My lord, if he wants his he wants his money back, my lord, then your lordship
No,
will
no,
pass
my
that
lord.
order only, my lord. Because
That is
if
the-
he's
that
going
is
on
the
arguing that,
purpose.
my lord, then your lordship will pass that order, my lord. We'll forfeit 25%, refund the balance.
My
my
lord,
lord.
we will be
If he-
paying the balance 30%, my lord.
Then say that.
That is the thing.
Unnecessarily,
That is the thing. I have said so before your lordship, my lord.
Lord, if he's relying on Shanmuga value, then Lord, it will not cast eyes for
Shanmuga
this.
value said that other than 25%, nothing can be forfeited. They have already forfeited.
You are now ready to pay the balance amount
Yes,
of
sir.
30%.
Absolutely.
Now, what was the order passed in the
Well,
writ petition?
In the order passed in the writ petition is, my lord, my lord, that is an order 11th March 2024. Your lordship has recorded. My lord, can you look at first page of your the papers I have handed over to your lordship? In the writ petition,
আপনি যা দেখাচ্ছেন আমাদের please give a copy to us.
in the writ petition, my lord, the appellants challenge the decision of the respondent
Yes,
bank
yes,
to
yes.
forfeit
So
the
now, 30% of the amount is yet to be paid.
only, my lord. That is now required to be paid.
This intra-court appeal by the writ petitioner is directed against the order dated 11th March 2024 in WPA 2043 of 2024. In the said writ petition, the appellant had challenged the decision of the respondent bank to forfeit the earnest money deposit and further deposits made by the appellant on the ground that the appellants could not comply with the conditions by making full payment within due time. The appellant contended before the learned single bench that a sympathetic approach may be taken in the matter since the petitioners were unable to pay the balance amount due to medical condition of the second appellant, the wife of the first appellant. And in this regard, relevant documents were also placed before the learned single bench. While disposing of the writ petition, the learned single bench observed that nothing in the decision taken by the bank prevents the writ petitioners to approach the respondent bank for a private TT as it transpires that even subsequent attempts of the bank to sell the said property have met with failure. Accordingly, liberty was granted to the appellant/writ petitioners to approach the respondent bank for entering into a private treaty to purchase the property and/or if a further auction is held, to participate in the said auction irrespective of the forfeiture of the deposits at the earlier auction. During the when the appeal was heard on 4th of September 2024 and the submissions made on either side were noted. Subsequently, when the matter was heard on 25th of September 2024, the court recorded the submission of the learned advocate for the appellant that certain discussions have taken place between the appellants and the respondent bank, and that there are good chances of the entire matter being settled, and requested the hearing of the matter be deferred. Accordingly, the matter was adjourned. With the said order dated 25th of September 2024, the court recorded the submission made on behalf of the appellants that they are ready and willing to deposit 30% of the balance amount within a time frame. Subsequently, the appellants appear to have approached the respondent bank and expressed their willingness to deposit the 30% of the balance amount so as to enable them to get the property and a sales certificate to be issued in the name of the appellants. This proposal made by the appellant appears to have found favor with the respondent bank.
My lord, we declined because it was not in terms of the statute. Not we could not have extended, not because that is beyond 180 days.
No, this appears to have been found. Use this.
This proposal made by the appellant appears to have
Found to be favorable to the respondent bank, but on account of the statutory embargo, the respondent bank would not be in a position to extend the time for payment of the balance 30% of the sale price. And therefore, the appellant has come before this court seeking for appropriate orders. We are conscious of the fact that there is a statutory bar for extension of the time for payment of the sale consideration pursuant to the auction conducted by the respondent bank. However, taking note of the peculiar facts and circumstances of this case, and also noting the fact that the bank is unable to sell the property despite three fresh auctions were held. In the interest of, not only in the interest of the appellant, in the interest of the respondent bank, this court is inclined to pass appropriate directions so that the matter can attain a finality. It is made clear that this order is being passed considering the peculiar facts and circumstances of the case and not to be cited as a precedent. Accordingly, the appeal stands disposed of by directing the appellants to pay the balance 30% of the sale price within a period of
within 15 days, my lord.
Within 15 days from date, and if the amount is remitted, the respondent bank shall receive the same and issue sale certificate in favor of the appellant within a week from the date on which payment is made.
Extremely grateful, my lord. Extremely.
Lord, a default clause, my lord, if they fail.
That should not be any.
Not required.
I will paying certainly. Otherwise, my lord, my 70% already gone.
Item number 3.
Grateful.
I appear for the appellants, your
How
lordship.
much time you want?
60 days, your lordship.
How much time did we grant?
30 days.
This matter has been listed under the caption to be mentioned. It is submitted by Mr. Sharaf, the learned advocate, appearing for the appellant, that the court, in its order, court while dismissing the appeal in the order by order dated 21st January 2025, directed the appellant to file a statutory appeal within a period of 30 days from the date of receipt of the server copy of this order. And if such appeal is filed, the appellate authority was directed not to reject the appeal on the ground of limitation, but to proceed to take a decision in accordance with law. The learned advocate for the appellant submitted that due to unavoidable circumstances, the appellant is unable to prefer the statutory appeal within a period of 30 days from the date of receipt of the server copy of the order and request for extension of time. We have heard the learned government counsel on the above submission. Considering the peculiar facts and circumstances, the time for filing a statutory appeal is extended by a period of 60 days from the date of receipt of the server copy of this order. And if the appeal is filed, the appellate authority shall not reject the appeal on the ground of limitation, but to proceed to take a decision in accordance with law. In the event the appellant does not file the appeal within the extended time, the benefit of this order will not inure to the appellant, and the appeal will stand dismissed in its entirety, or automatically dismissed in its entirety without further reference to this court. School student, you'll call them. No, school students you call. The teacher is also.
Students, please come forward.
Please come forward. Come near the mic. You are from which school?
From DPS Newtown.
You use the center mic.
Oh, Central.
Ah,
We're from Delhi Public School, Newtown.
Newtown. From which class?
We're from grade 11.
11, grade 11. How many of your parents are lawyers?
I think
Huh? Yes. Where is your father, mother, both of them? They are practicing here. What is his name? Come forward, no?
sorry. Nanchand Bihani.
So you want to be a lawyer?
It's an option.
It's an option. Huh? Why you are not impressed by your parents' performance?
Of course I am.
Hmm?
Of course I am.
Yes. It's a good profession. Huh? Some of you can consider taking up laws because most of you are focused on engineering, medicine, some literature, history, want to become professors. But law is a very interesting field. The times have changed. There are multiple options. So for which to get into a good university, you have to appear for the common law admission test, CLAT. And depending upon your scores, you will be placed. Of course, there are several private universities in West Bengal, outside West Bengal. Multiple options are there. After you pass out, there are umpteen number of avenues. So you can all seriously consider choosing law as a profession. Best wishes. Yes, ma'am.
Thank you so
Thank
much.
you.
Thank you so
Yes, please.
Audience at daily list matter item number 1.
May it please your lordships, my lord, I am appearing in item number 1 for the appellant. Lord, we have filed a cross objection. There was a delay of 978 days. My lords, by the order of 28th June 2024, lords, my learned friends were directed to file an affidavit in opposition within 2 weeks. It's not been filed. We have not been served. Well, I'll indicate what is the point. Lord, it's 978 days, but really it's not 978 days. It is 333 days. But although we have made the calculation as 978 because of this reason, my lord, we had filed a writ petition on a point on the Stamp Act. It was held in our favor. My lord, the state preferred an appeal, which is pending adjudication. My lord, thereafter, my lord, an order is passed in a similar matter, my lord, which is on 12th of July 2023. Same point, my lord, decided in a different, my lord, angle. That opened up a legal avenue for us. And my lord, thereafter, my lord, we filed this cross objection, taking cue, my lord, from the decision in that judgment, which was of, my lord, 12th July.
Writ petition went in your favor.
Writ petition is in our favor, my lord. That is dated 3rd of May 2019, against which my learned friends have preferred an appeal, which is pending adjudication, my lord. Thereafter, my lord, in a subsequent writ petition where we are not a party, my lord, that was decided on 12th of July 2023. So, my lord, this was in 19, that was in 23. There, my lord, a very similar point was decided with regard to the Stamp Act, which, my lord, opened a legal avenue for us.
What legal avenue?
My lord, the
You are keeping that as
interpretation,
a secret.
I know, my lord, the interpretation of the law, my lord, has been taken in a different angle. Stated, I'll indicate, my lord. Kindly,
Can that be a cause of action to file a cross appeal?
my lord, we have, because my lord, we have indicated in the cross appeal. It's the same point, my lord. The same point has been decided.
Succeeded before the learned single bench.
Not completely succeeded, my lord. It's a rate which is decided. So, my lord, our contention is that it is 0% because the properties are outside. So the single judge said it is 0.5%, against which, my lord, my learned friends are aggrieved. The appeal is pending. Now, my lord, in the subsequent decision in Indorama, it has been held that nothing is required to be paid.
No, that cannot be a sufficient cause.
My lord, I'll kindly permit us to indicate, my lord, that
It be a cross objection. It cannot also be a cross objection.
it
Or
is a
you need to go before the single bench for
My lord.
review of the order, saying that there is a subsequent review. Even then, the review petition, there are good chances of it being dismissed.
It will be dismissed, my lord. That is
because you are trying to seek review of an order
through a
based on-
judgment, subsequent judgment. So it is not permissible. That is the reason, my lord, the cross. I'll indicate, my lord. The point
You
is
should have filed a
holistically.
regular appeal, not waited for the state to file an appeal and then file a cross appeal with 900 days delay.
My lord, state filed it with a delay, and state filed it, my lord, 800 days delay, which was condoned. My lord, my petition is, my lord, 333 days delay. It's a cross objection. It's a cross appeal under Order 41, Rule 22, and my lord, with the delay is, my lord, essentially a 300 days delay, my
It's
lord.
not on the question of maintainability
I
of the
understand
cross
that, my lord.
appeal, but on what ground the cross appeal is being sought to be maintained.
My lord,
On a basis of the subsequent decision of a learned single bench. Can that be a ground for a?
Not only that, my lord, we have taken additional
All right,
grounds.
You file your affidavit.
Yes, your lordship, it's ready.
That appeal is pending adjudication as item number 3, the next matter, my lord.
Where the
So, my lord, 1 and 2 is this matter, my lord. And item 3 is, my lord, the other writ petition from which, my lord, which has been carried in appeal before your lordship. My lord, the issue is the same. So, my only prayer is, my lord,
Who will appear for item 3, your appeal?
no, my lord, my learned senior is appearing, my lord.
Well, I do not know the facts of this case, but what I believe is that by Lennox friend's case, there is no question of transfer of an immovable property, which is there in my case. And I have taken out an application for amendment of the memorandum of appeal, which has been allowed. And the matter is now set for hearing.
So therefore, technically, we'll have to hear your appeal first.
Yes, I think.
So if you hear appeal and decide,
Yes.
that will have a direct impact
On
your
our app, on my cross appeal, my lord. I'm very grateful.
Without cross-objection, that will have a direct
So you have not
impact, perhaps.
preferred, Mr. Bagh, you have not preferred any cross appeal. You have preferred a cross-objection.
Cross-objection, I stand correctly. It's order 41, rule
If
22.
you are aggrieved by a decision, you
Lordship.
have to prefer a cross appeal, not a cross objection.
No, it's not the decision that we are aggrieved by. That is the reason it's not a cross appeal, my lord. We are aggrieved, my lord. It's a point of law which we are urging
Against
before
any
the honorable court.
observation. Against any observation.
Against the finding, my lord. That, my lord, the single judge's, my lord, decision was that, my lord, 5.5% is the, my lord, stamp duty which is required to be paid. My lord, we are now contending, and this is not, my lord, taking cue from, it's my lord, an independent legal submission that the interpretation of the provision is that nothing is required to be paid, it will be 0%.
See, all right, that is on the
Lordship.
merits of the matter.
My lord.
But then, can this be a sufficient cause for continuation of delay? The decision in the 2023 writ petition
My lord.
was rendered much after your writ petition was disposed of,
My lord.
partly allowing your writ petition
Lordship.
by order dated May 3rd, 2019.
That's the original writ petition order, my lord. The, my lord, subsequent order is 2023, my lord.
You think over what to be done.
Lord, may I only pray for this? For ends of justice, my lord, since the same point is involved, there's already an appeal which is pending before your lordship in our matter.
Ends of justice, whether that
Lord, may I very
extended to you is the question.
may I very humbly submit this?
Not in the-
May subject to, my lord, being chided by your lordship, my lord, only this much. It's a point of law, my lord. So today, my lord, there's no factual addition in the cross objection. May I indicate our cross objection? I'm sorry. Two paragraphs of the petition.
Cross objection may not suffice. Your ground number 9 at page 4 of the memorandum of cross objection. In the order impugned, it was held that you are liable to pay half
Rate, my lord.
Now you say you
No
are not-
tax. No tax. Article 265 is.
So you are directly challenging the decision.
May I
Not
very.
by way of a cross objection.
I understand that, my lord. May I very humbly submit this? It's a point of law, my lord. Even if we don't.
You file an appeal along with 1,500 days delay, we will see. That's the only way you can do.
Lord, may we come back? My lord, kindly permit me some time. I'll come back and try and address your lordship. My lord, in that case, I'll, my lord, take you from what is falling from your lordships. We'll do the needful. My lord, kindly permit us to come back then.
Because virtually you want the order to be set aside. That portion of the order which went against you.
My lord.
That cannot be done
My lord.
in a cross objection in the state's appeal.
If the ultimate
My lord, may I be permitted to come back
Mr.
next
Bhatt,
week,
the
lordship?
ultimate finding is in your favor, but there are some observations against you.
Which, my lord, we are.
But it is not that you are challenging the finding. You are saying that yes, we were directed to pay half %, we are not liable to pay anything.
That's because, my lord, it's.
So that cross objection may not be the.
May we come back next week, my
We
lord?
have
I'll
heard
try and
so-
assist
so-
my lords.
May I file my affidavit?
We'll also, my lord, get
correspondents have
the
filed
reply ready in
their,
the meantime.
affidavit in opposition to the application filed for continuation of delay in filing the cross objection. Continuation of delay
Thank you.
of
Will the copy
978
again, sir?
days in filing the cross objection. After we have heard the learned advocate appearing for the cross objector for a considerable length of time, we are of the prima facie view that this cross objection will not be maintainable, since essentially the cross objector seeks to challenge the finding rendered by the learned single bench in the writ petition filed by them, which was disposed of by judgment dated May 3, 2019, which is subject matter of the appeal filed by the state in APO 96 of 2024. The attempt of the appellant appears to be to set aside the finding rendered by the learned single bench, whereby there was a direction upon the cross-objector to pay stamp duty at the rate of 0.5%. That apart, the cross-objector seeks to maintain this cross-objection by placing reliance on an order passed in another writ petition. Anjan, you give the other file, item 2.
My lord, that's at page 58 of the petition.
Oh, it is there.
Indorama versus Collector of Stamp Revenue, my lord.
Another writ petition in WPO 3281 of 2022 with WPA 22339 of 2022 dated 12th July 2023. Against the said order, the writ petitioner has preferred an appeal in APO 114 of 2023. Thus, we are of the prima facie view that the cross-objection may not be maintainable, more particularly when the cross-objector seeks to challenge the finding rendered by the learned single bench in the writ petition filed by them, apart from placing reliance on a decision which was rendered much subsequent to the disposal of the writ petition filed by the cross-objector. Faced with the above situation, the learned advocate appearing for the cross-objector requests time to discuss the matter with his client and get back. List the matter after 4 weeks.
I'm very deeply obliged, my lords. Very deeply obliged.
Then APO 114 of 2023, what to be done, sir?
Well, at APO, this has to be fixed for hearing because
All
everything is complete. I took out an application for amendment of the memorandum of appeal, which was allowed. My learned friend, the state was given an opportunity to file an objection.
Sir,
They have served a copy of objection as we have replied. The reply has been filed. So pleadings are complete.
Reply not yet filed.
Well, my reply, rejoinder rather, has been filed. They have served a copy on us. To which
Where
we
is
have
your affidavit in opposition?
Your Lordship, I am not there in item number 3, Your Lordship. I was only there in item 1 and 2, Your Lordship.
And who will appear? Nobody to appear.
Your Lordship,
Then we will allow the appeal.
Your Lordship, I don't have instructions, Your Lordship.
Somebody should be here now for the state.
I apologize, Your Lordship, but
Who appeared for the state on the earlier occasion? Resolution is only at 3:30.
I believe on the earlier
At 11:30.
Mr. Saleh,
Mr. Siddiqui had
Your
appeared.
Lordship, Mr. Siddiqui is having fever. I am told he is not in court today. In fact,
He was there in the morning, but he may have left. But I don't know.
His clerk informed me in item 1 and 2, he was my leader.
My lord, I was humbly submitting your lordship will fix a date for hearing. We shall intimate him, give him sufficient
Sir, I
time
think the
to get ready.
appearance has gone down wrong. Huh? But respondent, nobody is appearing.
সকালে দেখেছেন আপনি না আমাকে ওনার ক্লার্ক বললো যে
Okay. It is submitted by the learned senior advocate appearing for the appellant that the pleadings are complete. However, the affidavit in opposition, which was served on the learned advocate for the appellant, has not been filed in court. We are informed that the learned state counsel who is appearing in the matter is indisposed. Let the affidavit in opposition be filed in the department within a week. List the appeal for hearing when March. List the appeal under the same heading for directions so that the affidavit in opposition can be taken on record. After
Your
2
lordship
weeks.
is directing the appeal to appear for directions.
After 2 weeks, let the pleadings be complete. Then we will see.
I think their objection has to be filed. That's the only thing.
Probably they are carrying it with them.
Yes.
Let it come after 2 weeks.
I mean, from 2 weeks.
Well, there is some urgency in this matter because this registration of the scheme of arrangement is in limbo for some time. But let us see.
Next.
Item number 4.
If it may please, my lords, I am for the respondent.
My appeal, my lord, it appeared to be good one, my lord, when I was started reading, my lord. By the time I finished, my lord, I found it's a case, my lord, where there is no meat. My lord, it was a transfer pricing matter, my lord, which would have been a good case, my lord, but the commissioner's order, my lord, which has been affirmed by the ITAT, my lord, it serves the SSC's purpose well, my lord. My lord, the SSC, Lord, had taken Lord some services, Lord, from its associated enterprise, and Lord, the transfer pricing officer, Lord, found that the ALP was nil. Lord, this was challenged by the SSC along with others, Lord, before the appellate court or the Lord CIT appeals. Lord, the CIT appeal, Lord, if Lordship finds the reasoning, Lord, it's apt. Your Lordship kindly takes, Lord, page 43. Lord, page 43. Lord, the findings are at paragraph 6. I'll take your Lordship, Lord, at page 44. Lord, the first paragraph, page 44.
So for 12-13, the appeal was allowed.
Yes.
That has attained finality.
And Lord, kindly see, my Lord, page 44, the reasons, Lord, he has given good reasons here also, my Lord. The fourth line, the learned TPO rejected TNMM without giving any reasons. The learned TPO, though selected CUP as the method for benchmarking in such situations, but he himself failed to cite even a single comparable company with comparable services.
Probably he followed the earlier year.
Yes.
Please come. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 is directed against the order dated 27th April 2023 passed by the Income Tax Appellate Tribunal C Bench Kolkata in ITA number 1639/KOL/2019 for the assessment year 2013-14. The revenue has suggested the following substantial questions of law for consideration. Page number 6 and 7, A, B, C, D. We have heard Mr. Om Narayan Rai and a senior advocate appearing for the appellant, assisted by Mr. Soman Bhattacharya, learned senior standing counsel for the appellant, and Mr. So-and-so, learned advocates appearing for the respondent SSC. The revenue was unsuccessful in their challenge to the order passed by the Commissioner of Income Tax Appeals within bracket appeals -22, Kolkata within bracket CITA dated 22nd May 2019. The issue which fell for consideration before the respondent SSC challenged the decision of the transfer pricing officer within bracket TPO who disallowed the management fee as claimed by the SSC. Challenging the said decision, the CITA considered the appeal and found that the assessing officer had entirely relied upon the order passed by the TPO for the immediate preceding year, namely assessment year 2012-13, without making a fresh reference. The assessee contended that each year of assessment is an independent proceedings, and the assessing officer was required by law to make a fresh reference for the year under consideration. That apart, the CITA noted that the order passed by the TPO for the immediate preceding year, AY 2012-13, was challenged by way of an appeal before the CITA, and the appeal filed by the assessee was allowed by order dated 29th March 2019. It is not in dispute that the said order has attained a finality.
Lord, only one thing, Lord, that the appeal filed against the order of ITAT in that order, Lord, was dismissed on the ground of low tax effect.
Attained a finality as the revenue could not prefer an appeal on account of the low tax effect.
Dismissed. Appeal was dismissed on account of low tax effect.
Attained a finality on account of the revenues appeal being dismissed on the ground of loan tax sale. Be that as it may, we find that the TPO, though selected CUP method, CUP all capitals, as the method for benchmarking in such situations, he failed to cite even a single comparable company with a similar comparable service, despite the assessee having submitted the detailed nature of services received and the benefit obtained by it. We find that the order passed by the CATA to be an elaborate order, considering all the facts and figures placed before it. Ultimately, the appeal was partly allowed. The revenue carried the matter by way of appeal to the learned tribunal.
Page 67 of the tribunal's order, my lord, of the paper book, my lord, page 67, paragraph 9.6, last 3 lines, my lord, are important.
We find that the learned tribunal has reappreciated the factual position and dismissed the appeal filed by the revenue. It is relevant to note that the learned tribunal has recorded a specific factual finding that the claim of management fee expenses has been accepted by the department and no addition has been made for the same in the assessment year 2014-15 and assessment year 2015-16.
Page 64, last 3 lines, my lord. It has been found, my lord, that services, my lord, were indeed, my lord, taken. Therefore, my lord, couldn't have been nil.
That apart, we find that the learned tribunal has also taken note of the decisions of the other high courts and that of the coordinate bench of the learned tribunal. Thus, we find that the learned tribunal, upon reappreciation of the factual position, has rightly dismissed the appeal filed by the revenue, and we find no good grounds to interfere with the said order. According, the appeal filed by the revenue fails and is dismissed, and the substantial questions of law are answered against the revenue.
I am grateful, my lord.
Yes.
Item number 5.
My lord, kindly come to page 49, my lord. The finding of the tribunal. Paragraph 16. हो जाने दीजिए।
So, one issue is depreciation on goodwill, and the other is long-term.
Set off. Set off.
But then,
My lord, just they're pointing out why, what is the discrepancy in this order, my lord?
no, the
Paragraph-
scheme of the tribunal essentially on the first issue.
I'm not
Say-
challenging the scheme, my lord.
No, you can't.
No, I'm not on that. There was some. Here, my lord, what has happened? The appointed date was 1st of January 2013. But the assessee has calculated the goodwill on the basis of balance sheet as on, well, just a moment, 31st/12/2014. So the calculation itself is flawed. Here, what is the observation of the tribunal, my lord? Paragraph 16. I'm just quoting, my lord, the relevant portion in the middle, where the font is changing, my lord. The AO, after examining the scheme of amalgamation and on the basis of detailed documents furnished by the assessee, came to the conclusion that the claim of depreciation is not correct for various reasons, such as swap ratio of shares was not based on balance sheet as at 31st/12/2014. This is incorrect, my lord. Here, my lord, can you come to page 16, my lord? Order of the assessing officer.
No, that issue, the tribunal did not go into that.
No, yes.
It said that the scheme of amalgamation was approved after notice to all stakeholders,
My lord.
and including the income tax department. You have not raised any objection.
My lord.
The scheme has been approved.
Approved.
And whatever may be the appointed date, can you now say they should not have, the swap ratio should not have been determined on the basis of the balance sheet as on 31/12/2014 and not on 1/1/2013?
My lord, the appointed date is the relevant date. That is the effective date. The order of the NCLT was passed on 9th of December 2015 with appointed date 1st of January 2013. So on the date of 1st of January 2013, what was the balance sheet? The calculation has to be done on the basis of that balance sheet. That's why appointed date was mentioned.
But
my lord,
this is for which assessment year? 15/16.
Yes, my lord.
13/14, 14/15 you have accepted.
My lord, here the submission of the departmental representative on page 48, my lord.
Yes.
In the paragraph 15, middle portion, bold letters, my lord. The learned DR contended that the depreciation for 14/15 has been disallowed by the AO.
No, but in the previous page, you see page 47, para 14.
My lord.
Learned counsel submitted that.
That is the submission of the
That's
assessee.
true. On facts, is it correct
But
or wrong?
the revenue has contended that this was disallowed, my lord.
They say it was allowed. The department says it is disallowed. They should produce some order.
But assessment year 13/14, the revenue did not dispute that has been allowed. That is the first year. 14/15, it was originally allowed. They reopened that case. So that's how much but the first year, assessment year 13-14,
14, it was
even the
allowed.
revenue did not dispute before the honorable tribunal that it has been allowed. So that was the first year.
So
This is-
14-15, now it's reopened.
They have reopened it. That's been, so there will be several
So
grounds.
13-14 stands.
Is the first year.
First year. That's the first year.
First.
Let me take instruction on this specific issue, my lord.
No, his submission,
But I
just reading it.
Page 44, my lord, the continuing paragraph, the last 4 lines, even the order was placed before the honorable tribunal. Page 44, the last continuing paragraph, last 5 lines. That council also submitted that assessment year was duly given in assessment year 13-14 and 14-15 by claiming depreciation and goodwill, which was duly allowed by referring to assessment year 13-14 dated 25th December 2016, copy of which
So
is placed.
13-14 first year it was allowed. 14-15 was allowed. Subsequently, 147 they have reopened the assessment. It's pending. But at this stage, how to rework the entire matter? This was considered in the scheme of amalgamation. It was been approved. I think there are several decisions on this
Yes,
point.
but in fact, one of the tribunal might refer to precedents, but it referred to 2 decisions. My lords will find at page 50, electro sales
I
India.
remember having
One of the matters came before my lords, Purvanchal, which was followed here. Kindly see at page.
no, in the Madras High Court. Vaguely remember.
My lord, kindly see this.
It becomes, it attains finality. You have got no jurisdiction to reopen.
But can you have a look at Purvanchal?
There should be some sanctity to an approval of a scheme of amalgamation.
My lord, not on the issue of the approval, my lord.
And moreover, 13-14, the
My lord,
first
kindly see this, my lord, the order of the assessing officer. Just one paragraph, my lord, I will.
The best copy है पूर्वांचल की कॉपी है दिया है
The tribunal has referred to some decisions.
Yes, but at page 50, my lords, please take note. They have extracted from.
Those questions are basically when the depreciation on goodwill can be allowed or not. I'm not on that issue, my lord. My lord, is that the foundation itself.
No, you can't. You can't argue a different case. What was your case before the tribunal? Your case before the tribunal is 14-15. It was not allowed. But the fact was that a scheme was approved by the Calcutta High Court. That order has attained finality. The issue which tribunal considered, or you also, they pressed into service, was whether at this stage you will be able to reopen the issue. The court has followed several cases.
But that is not my case, my lord. Here, I don't want to reopen the issue.
Can't do that, sir.
My lord,
You are on a 260A appeal.
I'm not on the reopening that. I'm not challenging that amalgamation, any part of the amalgamation, my lord. Here, how the accounting method has been applied by the.
Sir, have you got this judgment, page 52, the extracted portion, para 4.5. Honorable Madras High Court in the case of Pentamedia Graphics Limited was right.
Yes, no, then single judge will please.
This was not the ground saying that on which date the balance sheet should be reckoned.
My lord, kindly see this, my lord, assessing officer's order, my lord.
Yes.
Why he has disallowed that?
Page
16, my lord. In the middle portion, my lord, from the above, it was understood that the computation of any consideration which requires additional payment, in this case, which is metamorphosed into goodwill shall have to be estimated as on accounting date for amalgamation, which is in this case would be 1st of January 2013. The assessee at the time of amalgamation computed the swap ratio of shares at 1:24, calculating it on the basis of provisional balance sheet as on 31st/12/2014, which is in clear violation of AS 14 as well as the scheme approved by the High Court White Para 13(1). Hence, fair value itself has not been arrived at. The plea of the assessee White Para 4.1 of its submission that the valuation of the shares was done on the basis of immediately available balance sheet of Ramuk scan, that is 31st/12/14, is unacceptable as because there is no such balance sheet in accounting terms for the date 31st/12/2014, which is it.
Then what is the finding of the commissioner?
My lord. Commissioner's finding is page 28, my lord.
You are virtually,
My lord.
the CITA has set aside the order of amalgamation. That's what he has done, which is wholly prohibited. And he has said that this is a clear case of a tax avoidance tool. That is principally, that's what has been held in various decisions. That can't be done. See, once the shareholders approve the manner of valuation, courts have said that you can't sit in judgment over that.
My lord, here the assessee what I was trying to impress on my lord, the appointed is the relevant date. Swapping of shares has to be done on the basis of that balance sheet. balance sheet as on one that.
No, that valuation has attained a finality is what the.
No, my lord, here is what SSC has taken the balance sheet of 31/12/14.
That was to adopt the valuation of the shares. That was placed before the Calcutta High Court, and that scheme was approved.
No, my lord, that was
Yes.
not. No.
The part of the swap ratio is a part
Swap
of.
ratio.
No, can you say
My lord,
please?
if that would have been done, the Honorable High Court would have given the appointed date as on 31/12/14, not 1st of January. Here, in the scheme of amalgamation, my lord, on a particular date, order is passed with the anterior date. Effect is given anterior date.
In more than one place, the CIT appeal says that the transaction of amalgamation is a clear case of tax avoidance. Can you take such a stand? Is the issue. Especially this valuation was part of the scheme.
Lordship, and can you see page 44 at the top note, the submissions which are recorded? I have the paper book before the tribunal. Note the authorities not called for the valuation report as well. At the top note. Land counsel submitted SSC's filed petition thereafter.
Admitted on so submitted. The same was communicated to regional director. Regional director issued a letter dated seeking various letters, inter alia, valuation report, etc., which was replied by letter. Thereafter, RD filed a report with affidavit approving the scheme. That the scheme was approved, the assessee pursuant to scheme so with effect on recorded all assets liabilities terms of accounting AS 40. certificate.
So this valuation part was also examined by the authorities before they agreed to the scheme. That's what, now I have the paperwork, the correspondence is there, affidavit is there. They filed an affidavit saying that the income tax department has not responded to us.
To show that affidavit? Normally the RD says we are neither supporting or opposing the scheme.
No, they ask questions. If my lords are pleased to have on page 86. आपके उस copy दिया हुआ है दिया page 86 if my lords are pleased to see. At page 86, the query from them, and kindly have a look at page 87, the bottom, serial number 4.
That the issue of standard accounting.
So this was a matter which was examined, and kindly see at page 90 is my reply, and not at page 91, paragraph 4. I submitted the report. But the affidavit is at page 95. And not that page, the scheme itself, not page 100, at 107, not 11.1, that swap ratio is there, not, it's part of the scheme, it's not outside the scheme.
The share exchange ratios in trade, it says swap ratio.
Swap ratio. So that 24 shares for every share. So for that valuation was given. In that valuation, the how the swap ratio. So that valuation goes with reference to the balance sheet of 31st December 2014. That is all. It was all part of the records. There's no
difficult. Then what is the other issue?
My lord, the other base issues are based on this issue.
In fact, in this decision, in the case of Pentamedia Graphics, you got a copy, no? Para 21, only course open. I sat with the Honorable Judge for quite a long time in the division bench. He's an expert. Her father was also a sitting judge of Madras High Court. He was also an income tax. Her grandfather also. Her husband is now a designated senior practicing. Her daughter is also practicing. Yes, sir. This appeal filed by the Revenue under Section 260 Cap of the Income Tax Act 1961 within bracket the Act is directed against the order dated 9 September 2022 passed by the Income Tax Appellate Tribunal C Bench Kolkata within bracket Tribunal in ITA numbers 2625/K1/2018 for the assessment year 2015-16. The Revenue has raised the following substantial questions of law for consideration. Page number 7, sir. Subpara I, 14I, 1. 2 not required. 3 I's. 4 not required. 5. That is all. We have heard so and so. The issue which fell for consideration before the learned tribunal was whether the assessing officer was right in denying the claim of depreciation on opening written down value of block of assets and depreciation on goodwill and other depreciable assets amounting to rupees 6, 24, 73, 357. The learned tribunal took note of the factual position, discussed about the finding rendered by the assessing officer as affirmed by the Commission of Income Tax Appeals within bracket CIPA, and proceeded to decide the matter. It is not in dispute that the assessee entered into a scheme of amalgamation with Ramuk, RAMUK, Scan Investment Private Limited, in terms of section 391 within bracket 2 and 394 of the Companies Act 1956, which was approved by the High Court of Calcutta by order dated 9/12/2015 with the appointed date as 1/1/2013. The assessing officer, after examining the scheme of amalgamation and on the basis of the documents furnished by the assessee, came to the conclusion that the claim of depreciation is not correct, as the swap ratio of shares was not based on the balance sheet as at 31/12/2014, rather than the balance sheet as at 1/1/2013, resulting in wrong calculation of swap ratio of shares, the assessee not taking the market value of the assets and liabilities while computing goodwill, etc., finally rejected the claim for depreciation of rupees 6, 24, 73, 357, including other depreciation claims. Thus, the issue which fell for consideration before the tribunal is whether the assessee is entitled to depreciation on goodwill arising from the excess of consideration paid over the net value of assets under the scheme of amalgamation, which was approved by the High Court of Calcutta after calling for objections from all the stakeholders, including the Income Tax Department. This is a Supreme Court. The learned tribunal noted that the Income Tax Department was given an opportunity to state any objections to the scheme of amalgamation, but they did not raise any objections. The learned tribunal took note of the various decisions and held that once the scheme of amalgamation is approved by the High Court, after giving notice to the stakeholders, including the Income Tax Department, to state its objections, if any, to the proposed amalgamation scheme, and if the revenue has not raised any objection, they would be stopped from challenging the validity of the scheme subsequently. The learned tribunal took note of a decision of the coordinate bench of the tribunal in the case of Electrocast Sales India Limited versus DCIT 2018-170 ITD 507 within bracket KO full stop ITAT bracket close. And held that the decision of the CIT within bracket A upholding the order of the assessing officer cannot be sustained. In the decision of the coordinate bench of the tribunal in the case of Electrocast Sales India, several decisions of the High Court, various High Courts have been referred to, of which one decision could be one decision would be very relevant to the facts and circumstances of this case, namely the decision of the High Court of Madras in Pentamedia Graphics Limited versus Income Tax Officer 2012 20taxman.com 755 within bracket Madras. In the said decision, the court took into consideration the decision of the Honorable Supreme Court in Marshall Sons and Company India Limited versus ITU 1997 within bracket 138 CTR within bracket SC page 1, wherein the Honorable Supreme Court held that once the scheme had been sanctioned with effect from a particular date, it is binding on everyone, including the statutory authorities. Identical issue was decided by this court in the case of Commission of Income Tax Calcutta 3 versus Purvanchal Power Company Limited in IT 8070 of 2015, dated 15th July 2022. Wherein the decision of the High Court of Gujarat in Vodafone SR Gujarat Limited versus Department of Income Tax 2013 within bracket 35taxman.com 397 within bracket Gujarat was taken note of, and taken note of, which decision was affirmed by the Honorable Supreme Court as reported in Department of Income Tax versus Vodafone SR Gujarat Limited 2016 66taxman.com 374 within bracket SC. Paragraph 46 and 47 of the decision by the High Court of Gujarat would be relevant. So this is available in statute. This extracted portion 46 and 47. Make a tick marker. That is page 5 and 6 of this. You put it in italics. Thus, on the law on the subject is clear, and there can be no ambiguity on the said aspect. And the revenue by way of revenue in an assessment proceedings cannot seek to reopen the matter. As pointed out earlier, the issue concerning valuation was sought to be reopened by the assessing officer. The question is whether this can be done. To be noted that the valuation issue was one of the specific issues which was raised by the regional director of company affairs when the scheme was submitted by the assessee. By communication dated 29th June 2015, the assessee was called upon to answer several queries and produce certain documents, and one of which was the copy of the valuation report of shares along with detailed calculation in support thereof to arrive at the exchange ratio. The assessee was also directed to forward a copy of fairness report of exchange ratio prepared by any merchant banker in the matter. The assessee had submitted the reply to the regional director of company affairs by reply dated 11th August 2015, specifically answering the query and also producing the copy of the valuation report furnished by the chartered accountants. Upon receipt of the same, the office of the regional director, upon receipt of the same, the office of the regional director issued notice to all the stakeholders, including the income tax department. However, the income tax department did not respond nor placed any objections or comments upon the scheme of amalgamation as presented by the assessee. This fact is evident on perusal of the affidavit filed by the regional director before the in CP number 447 of 2015 and CA 373 of 2015, wherein it has been specifically stated that as per the instruction of the Ministry of Corporate Affairs, New Delhi, a copy of the scheme was forwarded to the Income Tax Department on 8th July 2015 with a request to forward their comments / observations / objections, if any, on the proposed scheme of amalgamation within 15 days, but till the date of filing the affidavit before the High Court, that is on 26th August 2015, no comments / observations / objections were received from the Income Tax Department. That apart, we know that the share exchange ratio was very much part of the scheme, as could be seen from paragraph 11.1 of the scheme of amalgamation, which was presented for approval. Thus, we find that the issue was considered when the scheme was approved, and the learned tribunal was right, holding that the decision rendered by the order passed by the CATA affirming the order of the assessing officer is erroneous. Thus, we find no grounds to interfere with the order passed by the learned tribunal. Accordingly, appeal fails, dismissed, and the substantial questions are answered against the government. Yes, sir. Grateful. Grateful, my member.
In this matter,
I'm sorry, the assessment of 1314, my lords have taken note of.
I missed the one paragraph before you had. So, Anjani, give that. Yes, one. That appeal paper book along. Apart, it is relevant to know that the tribunal rightly took note of the submissions made on behalf of the assessee that for the assessment year 2013-14, which was the first year, the claim for depreciation of goodwill was allowed by the department and the matter attained finality. Though for the assessment year 2014-15, the same was allowed initially, but subsequently the assessment has been reopened and the matter is stated to be pending. Thus, this is also a very relevant factor which weighed in the mind of the learned tribunal. Yes, I'm grateful. Item 6.
I am for the appellant, my lord. In this matter, your lordship on previous occasion was pleased to direct me to serve the copy of the petition on the CIT judicial. My advocate on record tried to serve that, but they have not accepting that, stating that it has to be served first before the respondent here. So I have also served the respondent on in month of August. So,
and there is no counsel for the department?
No counsel for the department.
Affidavit of service. We have heard the learned advocate for the appellant. In terms of the directions issued earlier, the appellant appears to have attempted to serve notice on the where do you say that they refuse to receive?
No, actually they have advised them to.
All right, it is submitted.
I am not submit that they have refused.
Okay. It is submitted. No, please read it. No, attempted to serve notice in the office of the senior government pleader.
My lord, Commissioner of CIT Judicial.
In the office of the CIT Judicial. However, it appears that the appellant was advised to first serve the respondents in the matter. In this regard, affidavit of service has also so far as the service of notice on the respondent department is concerned, we find the same has been served and received in the office of the Deputy / Assistant Commissioner of Income Tax, Central Circle 2 within bracket 3 Calcutta on 31st July 2024. Since till date, no counsel has been nominated. We hereby nominate Mr. Om Narayan Rai, learned senior advocate and counsel for the Income Tax Department, along with Mr. Soman Bhattacharya, learned senior standing counsel for the department, as counsels to appear for the respondent department in the instant matter. Their appearance be regularized. Let copies of the appeal papers be served on the learned advocates for the department.
Deeply obliged.
Yes.
Item number 7.
I am for the respondent SSE, your lordship, in the matter.
Yes, sir.
Lord, this is Lord that 68 edition appeal, Lord. Lord, a classic case, Lord, where Lord, share application, Lord, money has been raised in excess of Lord 6.5 crore, Lord, by issuing shares at premium. Lord, if your lordship, Lord, kindly takes, Lord, I shall take your lordship, Lord, through snippets, Lord, of the assessing officer's order. And thereafter, my lord, I shall take your lordship, Lord, to the IT80's order. Lord, the IT80, my lord, has held in favor of the SSE only on the basis that documents have been furnished which show, my lord, that the identity, capacity, and my lord, genuineness of the transaction is proved. My lord, even if I assume for a moment, my lord, that identity and capacity is proved, my lord, genuineness will not be proved on the basis of documents. My lord, I shall show, my lord, why I say so. If your lordship kindly takes, my lord, the assessing officer's order, it begins, my lord, from page 10. Kindly take, my lord, page 11.
Yes.
Lord, second paragraph, last line. The authorized representative of the SSE was asked to furnish details and documents to substantiate the return of income filed by the SSE. Compliance by the SSE, my Lord, your Lordship will find the caption after the paragraph below. As there was compliance on the part of the SSE company, but certain facts were not clear, a final show cause letter was issued to the SSE company on such and such, and the contents of the letter are reproduced below. Now, my Lord, there are certain, my Lord, requirements, my Lord, given. Kindly take, my Lord, page 13.
Yes.
Notice under section 131, my Lord, the second caption. Even though notices under section 131 of the Income Tax Act 1961 was issued to the SSE company, but there was no compliance on the part of the SSE. The SSE failed to totally discharge its onus to prove a transaction to be true, even though the statutory notices and further refixation notices and further notice under section 131 of the Income Tax Act was issued to the directors of the company for personal appearance and recording of statement and obtaining deposition, and to substantiate that the alleged transaction was from genuine sources and not a bogus transaction, and also to produce the details and documentary evidences of the source of funding of the shareholders and justification of issue of shares at such premium. Thereafter, my Lord, it says SSE, my Lord, failed to discharge onus. Kindly have a look, my Lord, thereafter. SSE was required to furnish the following: personal appearance of the directors of the company as well as the directors of shareholding companies who had fresh share application and premium during the assessment year for recording of statement, and to ascertain genuineness of the transaction of the alleged increase in share capital, share premium, share application. Details of share, my Lord, I shall not trouble your Lordship with that. Kindly take page 14, first caption. SSE's incapability. The SSE could not produce the directors personally for recording of statements, even though enough opportunity of being heard was given to the SSE. Till today, the SSE has not been able to produce either of the directors. In view of his non-compliance, the undersigned has no option left but to get verification complete in all respect with regard to the identity and creditworthiness of the shareholders and the genuineness of the said application transaction in the garb of share application money. In the instant case, it is found that from the accounts filed that during the relevant assessment year 12-13, the SSE company alleged to have raised fresh share capital by issuance of shares having face value of ₹10 with premium value. The details of such increase are as under. My Lord, your Lordship will go from right hand side to the left hand side. As on 31st of March 2011, my Lord, the first value is, my Lord, 62,65,000. My Lord, face value at of ₹10, the original share value. My Lord, in 2012, it is 75 crores, 75,69,000. And my Lord, with shares, with premium, it increases, my Lord, to 93 crore, 9 crore 31 lakh 76,000. My Lord, this is the increase. My Lord, the increase in share premium, my Lord, is to the tune of, my Lord, 6 crore 52 lakh. My Lord, if 3.5 crore, my Lord, is deducted from the 10 crore and odd. Now, my Lord, kindly take page 16. Third paragraph. It is a fact that the reason for issuance of share at such price is not explained by the SSE. The shares of such company do not have intrinsic value. And my Lord, next line is very important. The balance sheet and the profit and loss of the SSE company clearly shows that the shares of the company do not have any intrinsic value, and a prudent businessman would not waste his money by investing in a company which has no prospect. The company does not have any sort of operation or business activity. During the year, the company lets out the whole amount of such capital raised and routes the said amount as investment in some other company. What can be the reason for raising share capital at such a high premium and investing the same in some other non-operative company, and that too, that company is a non-income generating company, is something that an ordinary person would be wise enough to understand. If the profit and loss account of those companies are perused, it will be seen that in most of the cases, the company is either having a bit of interest income or commission income or some such petty income, and the expenses claimed in those companies would either neutralize that income, or the returned income of those companies would be a loss return. No reasons can be found out as to why any prudent businessman invests in such companies where the earnings are nil, or the shares of those companies does not have intrinsic value. It is not normal in the normal day-to-day society, and there is no reason that any person would invest in such a company where there is no chance of having any business gain. And it is also true that no man would keep his money dumped in a company where there is no business activity, and chances of such money being recovered are almost nil. The nature of every human being is to generate money and get income out of that, which is the basic rule that each and every man follows. And only here in such case, in the case of such companies, can we find that reverse occurring. Now, my lord, he discusses, my lord, the modus operandi, and my lord, he makes the addition. Your lordship will kindly take, my lord, the commissioner's order, which begins at page 26. Lord, kindly take, my lord, page 28. Very interesting. Page 28, my lord, 4. First caption, my lord, non-compliance. Lord, this is the conduct of the SSC, my lord, in its own appeal. This appeal was filed on 13/4/2015. In this case, first notice of hearing was issued on 6/2/18, seeking compliance by 15/2/18. However, there was neither any response on the prescribed date nor any submission was filed. Subsequently, various notices were issued, but the appellant did not comply even once. Following notice, my lord, your lordship will find, my lord, 6 opportunities, 6 dates of compliance fixed. Remarks, my lord, no response, no submission received. Now, my lord, he proceeds on the basis of, and he, my lord, marks it. If your lordship takes, my lord, page 28, last line, the appellate proceedings are the first line of remedy to those who think that injustice has been done by the AO. My lord, he has emboldened them, and my lord, they do not appear. Then, my lord, the commissioner, my lord, from page 30 onwards, discusses cash credits. And, my lord, after having discussed, my lord, it does not find, my lord, any reason to differ with the assessing officer, my lord, it upholds the addition. Now, my lord, we come to the ITAT's order, which begins, my lord, at page 34. Now, my lord, till page 41, my lord, the submission of the assessees, my lord, have been noted from page 36 end till, my lord, page 41. My lord, one paragraph is devoted to the departmental representative submission. And, my lord, kindly have a look at page 42. This is what, my lord, finds favor with the ITAT.
Yes.
Paragraph 8. Before us, learned counsel for the assessee, referring to the paper book and details, has submitted that the share applicant companies are duly registered with the Ministry of Corporate Affairs, assessed to income tax. All the share applicants are filing income tax returns and books of accounts are duly audited. It is also claimed that all the share applicants have sufficient net worth to explain the source of investment made by them in the equity of the assessee company. Before us, various details of share applicants have been filed and they have been tabulated in the chart form reproduced below. Now, my lord, name of the party and PAN is given, amount invested is given, net worth is given, my lord, to show that it has capacity to pay. My lord, net worth is, my lord, being translated into the capacity to pay. And then copy of documents, my lord, there is a chart which runs into, my lord, 4 pages. My lord, page 45, the chart ends. And, my lord, paragraph 9. Paragraph 9, my lord, is the paragraph by which, my lord, the ITAT nails the department.
Yes.
From going through the above details, we notice that whatever best evidence which one can gather to discharge the onus cast under section 68 of the Act, that is to explain the nature and source of sum found credited in the books, has been done so by the SSC. My lord, I pause here for a moment, my lord. There are 3 things, my lord, at the cost of repetition, which, my lord, the assessee is to do in my lord, regard to discharge of its onus. My lord, burden will always be with it. First, identity. Second, creditworthiness. Third, genuineness. Merely by deposition of these documents, my lord, this is a question which I asked to myself, even if the first 2 are, my lord, said to have been discharged, identity and creditworthiness, does the, my lord, transaction become genuine? Am I not required, my lord, to prove that also? My lord, it has been held time and again by this honorable court and, my lord, up to Supreme Court, that this is the first thing that you have to do to discharge your onus, and my lord, onus only then shifts on the department to make further inquiries. you have to give some explanation as to why will a company invest in such a company which does not have any profit-making apparatus. My lord, I shall come to your lordship's judgment also recent most on this. My lord, this is one. The assessee has offered complete explanation to prove the identity and creditworthiness of the share applicants and genuineness of the transaction which have been routed through banking channel. So, my lord, genuineness is related to banking channel. Merely because I have not paid in cash, I have paid through bank, therefore the transaction is genuine. That, my lord, with my humble submission is not what is required to be proved, my lord, held. Once the assessee has discharged its onus, then it is the turn of the revenue authorities to examine those details and also render the explanation offered by the assessee, and then to form an opinion about being satisfied with such evidence or not. And so as to form an opinion, a proper satisfaction has to be recorded by the AOCITA. This is the mandate of Section 68 of the Act, which has two limbs. Firstly, the explanation to be offered by the assessee to explain the nature and source. Lord, nature and source. Nature, my lord, genuineness. You have to explain the genuineness. The assessee is onus. Nature and source, and second limb is the opinion of the AO to satisfy the veracity of such explanation offered by the assessee. In the instant case, except for personally not appearing before the AO in few cases against the summons issued under Section 131 of the Act, all the other details and evidences have been, my lord, this again is factually incorrect, except for personally not appearing in few cases, my lord, as if in some cases they appeared, in some did not. They have not appeared at all is what the AO has recorded. These details clearly shows that the investing companies, that is the alleged share applicants, are duly registered with the Ministry of Corporate Affairs. Books of accounts and financial statements are duly audited. They are regularly filing returns with the Income Tax Department as well as on the portal of the Ministry of Corporate Affairs. All the transactions have been carried out through banking channel. Source of fund is well explained by net worth of the share applicant companies. For instance, one of the share applicant companies, namely Aqua Wincom Private Limited, which has invested rupees 25 lakh in the equity shares of the SSE company, has a net worth of approx rupees 11.13 crore as on the close of the financial year. Another share applicant, namely such and such, my lord, he has gone on, my lord, describing that. I will show, my lord, the danger of relying on this also, my lord. And then, my lord, kindly have a look at paragraph 10, which makes the case most interesting. Paragraph 10, my lord, the ITAT, my lord, relies on its own decision in the case of Messrs. Inter-Securities Private Limited. And, my lord, a similar chart, as has been, my lord, detailed in the order impugned before your lordship will find at page 48. Just to show, my lord, as to how dangerous it is to say that merely because it has, my lord, a good track record in the books, it is also creditworthy. Lord, kindly have a look at, my lord, the chart.
But in that inter-security,
yes,
that's what they have extracted, is it?
Yes, that's extracted. I'm just showing something, my lord.
But there the details were furnished before the lower authority.
Yes, my lord, it only shows, my lord, these details only, my lord. I do not know, my lord, the full facts of that case, but something, my lord, which is very interesting.
It is recorded saying that all the above details should furnish before page 52.
Yes.
Before the lower authorities.
Yes.
In terms of so and so. Then
yes,
you come to the next page. Where did I see that? Source of source is also established. In
now,
that
my lord,
case.
Yes, here, my lord, he tries to show that since, my lord, they are creditworthy, that is the source. If your lordship kindly takes, my lord, the chart, kindly take page 51 once.
No, you skip over that decision, come to the finding of the tribunal.
My lord, only once, my lord, for my side, page 51. Something, my lord, which, page 51, my lord, kindly see item 12. My lord, it is the same assessee which is before your lordship. My lord, this assessee is investing there, and your lordship found the assessing officer's finding that it is not a profit-making company, my lord. I'll take your lordship, my lord, to the language used by the assessing officer. Lord, kindly see, my lord, page 16. Lord, 7th line from top at paragraph 3, top of the paragraph 3. The company does not have any sort of operation or business activity. My lord, it is this company which is creditworthy, my lord, in inter-securities. This is what, my lord, the balance sheet does. It is this company which, my lord, the tribunal found to be creditworthy in the judgment, my lord, which it is relying, my lord, to nail the department here. And the reason for creditworthiness, my lord, is the bank statement and, my lord, the the net worth? A company, my lord, has a net worth, has no business. My lord, it is for all of us, my lord, to anybody's guess, my lord, how it is making that money. Now, my lord, the reasons your lordship, it has quoted the judgment, my lord, inter securities. That judgment, my lord, continues. There are several other quotations. My lord, page 67, your lordship will find the extraction ends. Page 67, in the result, appeal of the SSC is allowed, and there, my lord, paragraph 12. Respectfully following the above referred judgments and decisions, and also considering the facts of the case, we find that the SSC carried out genuine transactions of receiving share capitals. Lord, in my very respectful submission, Lord, this is a startling conclusion. Genuine transaction on the basis of all this, Lord, Lord, then there is no case for the department anyway. In every case, my lord, it will be through banking channels, my lord, and we all know how we can create a facade of balance sheet. Now, my lord, I would straightway go to your lordship's judgment. This is, my lord, 2024-468 ITR 111. My lord, this judgment contains, my lord, a solid distillation of all the cases, my lord. Lord, paragraph 17 onwards.
How much time will it take? We'll continue.
I won't take much time, Lord.
All right. Paragraph?
Paragraph 17.
Actually, Mr. Dubey also has to make submissions.
Then, Lord, we can have it, Lord, as per your lordship's convenience.
Next will be Friday. Next Wednesday it will come. Mr. Dubey, next Wednesday will be convenient?
Just let me check, your lordship. Wednesday, I'm okay, your lordship. I'm okay on Wednesday.
Whether they have challenged this in Supreme Court?
Lord, I think...
You ask Mr. Ketan.
Lord, I thought, Lord, there was a challenge, but...
Madam, you have filed an appeal against this? BST. Just verify and...
Lord, last I heard, but Lord, there was some Lord, talk of withdrawing it, Lord, and going to the Vivad Se Vishwas. This is what I heard last.
Then this becomes final.
Yes. Your lordship, there are number of judgments from both sides by your lordships in this matter in the last 1 year.
In fact, Sri Leathers we held in favor of the assessee.
Number of judgments, your lordship, and the case to case. It has to be decided by your lordship case to case whether there is a question of law or not in the matter.
Yes, rightly said. Rightly said.
Yes, your lordship.
We have heard Mr. Om Narayan Rai and senior advocate assisted by Mr. Procedural for the appellant revenue. For continuing and Mr. V.N. Dubey, learned advocate, appears for the respondent. For continuation of arguments, list on Wednesday. Immediately after miscellaneous.
Much obliged.
The next two matters are for withdrawal, madam.
Because VSV.
Mine. No. But the next two matters in the list, madam, are for withdrawal because of subsequent development in the case.
Then have you got any communication from your client?
Madam, the CIT has allowed my appeal on remand. I was against the ITAT's order before my lord. ITAT had remanded. Now the CIT has allowed my appeal on remand.
All right. This is appeal filed.
I'm appealing for the respondent, not
and the learned advocate for the appellant.
The orders may be taken on record, madam.
One second. It has to be leave to withdraw this
in terms of the order of the CIT.
Since they are accepting the order passed by the Commissioner of Income Tax, so Principal Commissioner of Income Tax, Calcutta 2, dated 31/12/2024. For the above reason, the appeal is dismissed as withdrawn, and the substantial question of law suggested are left open.
Yes.
Same order in item 9. Also.
I'm appealing both the cases.
Now 8 and 9 common order may be passed.
Yes, madam.
I'm grateful, madam.
Sir, I am Papia Viswas. I have come from Krishnanagar. I have a 8 years old, 2 times transferred, closed, reopened for a front one. Now the final judgment is dismissed by an in charge. Sir, please, if you see my documents, please. I have just come to the chief of the Honorable High Court. Please see my copies. Lastly, I was so called. See the final judgment, please. Please help me. Shok was written by me. It was newly reopened for a fraud one. Second time, it was closed, and it
No,
has
then
been.
you have to file a criminal revision.
Sir, please see the papers, please.
No, against this order passed by the judicial magistrate, you can't come to the High Court and mention before us to.
Okay, that is the process. Primarily, I want to show what is happening there. Condition of the Krishnanagar court. They have boycotted me. I can't enter in the court. The staffs all are involved. If you see, please, I have given days, appearance days, 6 months, 21 days. And I submitted the put up personally. My file is missing. You see, put up how it is a
Your file is missing.
The staffs to
You
did
make
that.
a complaint to the district judge. If your file is missing, you make a complaint to the district judge.
Sir, now please, the case is final judgment is dismissed. I want, what is my request now? I want the final judgment at High Court. I got nothing. Everything is there.
You want?
Please, sir.
You can go to the Legal Services Authority.
Sir, I went there. They don't properly. Please don't mind. Please, don't.
In the City Civil Court campus, not in Kishannagar. Here in the High Court campus, they will tell you where the address is.
You tell any one of the advocate. Please help me. I want the final judgment here. Everything is at the case closed.
They will examine.
Please, sir.
You please
Sir,
tell us.
one point. His salary statement was exhibited in 2024, 1,98,500. Now it is 2024. I got nothing. Now it is dismissed by an in charge. I have written everything. I have written everything in
If you go to the Legal Service Authority,
Legal service, please don't mind. Before this, I went there for a read petition. They did not help me by giving an advocate. And finally, I got the dismissed.
No.
Final judgment.
Which Legal Services Authority you went in Kishannagar?
The chief of the LADCS is biased, totally biased, sir.
Over, madam, your case is dismissed.
Please,
in the city.
Sir, only one request. Can I have the final judgment here?
No, we can't have it here unless a petition is filed.
Yes. I will file the petition.
You appoint a lawyer.
Yes.
You get an advice from a lawyer and then file a petition. We don't know whether it's maintainable as a revision case before the High Court or you have to file an appeal before the lower court. We can't be advising you, madam, what to. We can only tell you, help you, saying that there is a legal services, West Bengal State Legal Services Authority is there in that City Civil Court campus. In the same floor, you have to walk down straight and take a left. In the other building, it is there. There will be a front office. You go and show them the order. Then they will examine, advise you what to do. Whether you can file a petition here. If you can, they will nominate a lawyer.
Okay. Okay, thank you, sir. Please make copies. Where are my papers?